The Federal Arbitration Act allows for the enforcement of arbitration provisions in many different types of agreements that permeate our daily lives. For example, if you buy a ticket for a concert, you are likely agreeing to litigate any claims that you may have from that event in binding arbitration. In arbitration, you don't have a jury of your peers. It's not a case in court. Instead, an arbitrator will decide the facts of your case and award damages, and that arbitration award will be binding. It will be difficult to appeal. Arbitration has many problems. Many of the problems of arbitration were exposed in New York Times and other publications, articles, and research showing that arbitrators are sometimes not neutral because their frequent clients are the major corporations that use arbitration the most. Many times an arbitrator is employed by, or connected at least with, in terms of the cases they arbitrate, a particular company versus an individual that might be that individual's only time going through the arbitration process. In essence, arbitration is a closed-door way of deciding a case. It's oftentimes confidential, it's oftentimes biased, and it prevents people from having cases brought in court, in public, and heard in front of a jury of their peers. Arbitration, fortunately, is not enforceable against Jones Act seamen. The FAA, the Federal Arbitration Act, explicitly exempts contracts of seamen from coverage, meaning that contracts of seamen, if they have an arbitration provision, they are generally void. The only exception, unfortunately, to that rule is in the case of foreign seamen. There is some authority enforcing arbitration agreements with respect to foreign seamen. We have litigated the enforcement of arbitration provisions with respect to foreign seamen. We understand the authority and we understand the risks involved with respect to foreign seamen and the enforcement of arbitration. There are certain conventions at play, such as the New York Convention, which governs the enforcement of arbitration with respect to non-U.S. citizens. We understand that convention and that authority, and we are prepared to make every argument available against the enforcement of arbitration in your case so that you can have your case heard by a jury of your peers. Arbitration agreements are generally not enforceable with respect to cruise line passengers from the United States. With respect to non-U.S. citizens and foreign cruises, however, arbitration agreements may be enforceable. We are prepared to make every argument available against the enforcement of arbitration in your case. And if arbitration is enforced, we are prepared to move forward to maximize your compensation and rights in the arbitration process.